koutou. Good afternoon, everybody. Can those of you at the back hear me? Yep, brilliant. Again, like always, please let me know, particularly at the back, if you are unable to hear me. Okay, welcome back. Today we're going to continue learning all about interpersonal violence offences that are non-fatal, non-sexual offences. So we're going to start by finishing off a group of offences that are built around liability built around bodily harm. And then we're going to move on to look at some specific defences that can be raised to all of these interpersonal violence offences that are non-fatal, non-sexual. And the defences are really interesting because in the defence of victim consent, which is where we're going to give most of our time when we come to look at these specific defences, you can really see public policy framing the approach that we take in New Zealand to that really essential question about to what degree are we going to permit individuals to allow violence or harm to be inflicted upon their body. So it's a really great example in criminal law where you can really see those big picture policy questions that we thought about at the start of last week's lecture really coming into play. So we'll have a look at that in the second half. For now, if you could cast your mind back to what we looked at last week, we started this topic of interpersonal violence offences that are non-fatal, non-sexual, by talking about common assault. That was the lower end of assault, common assault under section 196. We learned all about that. We learned all about the definition of the assault. When I did the workshops with you, it was really obvious just how great your understanding is of the definition of assault. And that's brilliant, right? That's going to hold you in really good stead to have that really fundamental understanding of how we define an assault. So we got to grips with common assault, and then we started to think about a group of offences that we talk about as being aggravated forms of assault. Now remember, when you're looking at specific offences, you would charge with the specific offence. So you would charge with a 202 capital C, an assault with a weapon, for example. Or you would charge with a section 193. So when someone assaults, they have this additional further intent to injure. So although we talk about them as being a form of an aggravated assault, the actual offence is the statutory provision on which you're trying to base the liability. So we looked at that second group, a whole different range of offences like assault with a weapon, like assault with that further intent, which is intent to injure under 193. We looked at the male assaults female, the assault of a child, those under section 194. So we looked at all of that in the second group of these type of offences against the person, these interpersonal violence offences that were at the heart of them, they all needed an assault. We needed to prove the actus reus mens rea of an assault, and then they had that additional aggravating element, whether that was the weapon, whether it was a male assaults female or a child, that it's the status of the victim. But they all were built on that assault. And finally, what we ended up with at the end of last week is that we started to look at a third kind of group of these interpersonal violence offences, which is where this is nothing to do now with assault. So we can park our understanding of assault in section 2. These are offences that are built on either the degree of bodily harm or the type of bodily harm. And that's where we got to last week. So we started going, okay, the degree of bodily harm, these are offences that are either involving actual bodily harm, which we know is just more than trivial harm, but not really serious. And we know that in the Section 2 definition part of the Crimes Act, to injure is taken to mean actual bodily harm. So we know that throughout the Crimes Act, when it talks about injury or to injure, we know they're talking about a level of bodily harm that is an actual bodily harm. Then we moved on and we thought about a different degree of bodily harm, which was grievous bodily harm, really serious bodily harm. So at the higher end. And we then thought about that actually it's a question of degree as to whether something can be seen as actual bodily harm or really serious grievous bodily harm. It's a question for the jury to work out. And then we moved on and we looked at different types of bodily harm. So we looked at wounding, we looked at maiming, we looked at disfiguring. And that's where we got up to. So now what we're going to do is look at some specific statutory provisions that either are built around the degree of harm or the type of harm. Okay? So now we're going to hit the new material. So let's have a look then at offences that require injury. And what's injury? How else do we talk about as injury? What kind of degree of bodily harm is injury? Actual bodily harm, brilliant, right? So we're now going to look at some offences that require actual bodily harm, that require injury. One of the really important ones is in section 189. So section 189, subsection 1 says that everyone is liable to imprisonment for a term not exceeding 10 years who with intent to cause grievous bodily harm to anyone injures any person. And then in the second subsection it says everyone is liable to imprisonment for a term not exceeding 5 years who with intent to injure or with reckless disregard for the safety of others injures any person. Where's our actus reus in either subsection 1 or 2? What's the conduct that has to happen here? Yeah. Injures, right? The key point in 189 subsection 1 or 2 is you have the same actus reus, right? To injure, actual bodily harm. What then distinguishes them is the mens rea. So at the time of doing the injury or causing the actual bodily harm, you have these different forms of mens rea. The more serious form, of course, is the intent to cause grievous bodily harm. So while you are committing the injure, while you are committing the actual bodily harm, what's been proven here, what needs to be proven here is that you had intent to cause grievous bodily harm. You had a more serious level of intention. And we know it's a serious offence because our penalty tells us it's up to 10 years. Subsection 2, again the actus reus is injury, so actual bodily harm, but here the mens rea is that the person has intent to injure, so they intend to cause actual bodily harm and then they cause it. Or they, with reckless disregard for the safety of others, end up causing actual bodily harm. So there that brings in a form of recklessness, right? They saw a risk and they consciously saw that risk and they consciously carried on. So actually what we've got in 189 is we've got these three different offences, don't we? Three different ways of being able to show a section 189. We've got, under the subsection 1, someone has the intent to cause grievous bodily harm and then causes actual bodily harm. Or in subsection 2, they intend to cause actual bodily harm and that's what they cause. Or they are reckless, they have a reckless disregard for the safety of others in their causing of that actual bodily harm. So the key thing to take away from 189 is that our conduct is injury. What makes one 10 years and the other 5 years is that mens rea distinction. Okay, subsection 1, you need the intent to cause really serious harm. Subsection 2, the intent to do the injury, which is actual bodily harm, or a reckless disregard for the safety of others. Section 191 is about where someone has the conduct is to injure again, so it's based on the actual bodily harm. Someone in effect causes actual bodily harm, injures another. But here they do so with intent to do a specific thing. Right? So they have an intent to commit or facilitate the commission of an imprisonable offence. Or they have an intent to avoid the detection of himself or somebody else in the commission of an imprisonable offence. Or they intend to avoid the arrest or facilitate their flight of themselves or someone else from being arrested for an imprisonable offence. So in the course of all of those levels of intent, and you just need one of those, the prosecution just has to prove they had an intent to either do paragraph A, B or C. They have to injure somebody. So the reason 191 is called aggravated injury is because the actus reus is just to injure, right? This fairly low level in terms of being just more than trivial or trifling harm, but not really serious. So they just have the conduct element of to injure, but they have the intention to do something more serious. And it's quite specific under A, B and C what needs to be proven their intent is to do. See why in criminal law, once you've got your building blocks, right, once you know your actus reus and you know your mens rea and you know how to find them, you can pull apart any offence, can't you? You can straight away work out, where is my conduct? Here it's to injure. Where are some words that are going to help me find my mens rea? And here it's the intention. Okay, so once you've got those building blocks sorted of your actus meus mens rea, you can then unpack and work out any of these offences. Okay, let's have another look at one that's built around injury. Now, this is kind of an odd section. This is trying to cover situations where someone does something that if the victim had have died, it would have raised manslaughter. So it's talking about situations where somebody does an unlawful act and an unlawful dangerous act that in any other circumstances, if they had caused the death of the victim, then that would have been manslaughter. But here, they have only injured, right? They've caused actual bodily harm through their unlawful act. They haven't actually caused the death of somebody. So 190 talks about that everyone is liable for imprisonment up to 3 years who injures, so causes actual bodily harm. In such circumstances that if death had been caused, they would have been guilty of manslaughter. So here we're talking about a kind of negligence. We're reading into it a mens rea of negligence, right? The reason I said this is kind of a quirky or interesting section is that although the title of it says injuring by an unlawful act, most commentators think that actually this would also include an omission. Because obviously manslaughter, as we know, under section 160, subsection 2, paragraph B, we know that you can have an omission that can cause the death of somebody, and that can be manslaughter. So most commentators say that section 190 would also be where somebody fails in a duty, so breaches a duty, and in doing so has injured somebody. And if in other circumstances that would have led, say, to a death. So it's trying to plug a gap, isn't it? It's trying to make sure we're covering situations where somebody does something or arguably doesn't do something, and in different circumstances the person would have died, it would have been manslaughter, but because they don't die, we don't want the defendant just to have the luck, right, that somebody hasn't died. We're trying to give culpability in different situations, and that's what section 190 is trying to do. You see, a lot of our criminal law, because we codify it, is about seeing gaps. When gaps come up in cases, for example, and then Parliament goes and brings in a legislative change. So we see we're plugging the gaps. Now we're going to look at some offences that are requiring a type of harm, whether this is the wounding, the maiming, the disfiguring, or causing grievous bodily harm. So that's the degree of harm. Right? So these group of offences are not about injury, not about actual bodily harm. They're about either wounding, maiming, disfiguring, or causing really serious harm. A really important section to get to grips with is the 188, section 188. Again, you can see by the penalty here, they're really serious offences, right? So in subsection 1, you've got a term not exceeding 14 years. If with the intent to cause grievous bodily harm, somebody wounds, maims, disfigures, or causes grievous bodily harm to a person. So again, shout out to me, where is the actus reus? Where are some of the forms of the conduct? Wound, brilliant. Anything else? Maims, disfigures, and brilliant. You guys have got it, right? By the time you get post-workshop, you'll be like, I've got this, right? So you've got your actus reus. Where is our mens rea then in subsection 1? Perfect. Right? Our intent to cause grievous bodily harm. So what lifts this is that we have an intention to do really serious harm, and then we either wound, maim, disfigure, or cause really serious harm. How does subsection 2 differ? What's the difference between subsection 2 and 1? Mens rea, perfect, right? Our actus reus is our wound, disfiguring, maiming or causing GBH. What's our mens rea in subsection 2? Intent to injure, meaning that when someone maims, disfigures, or when someone causes really serious harm, they only have to have intended actual bodily harm. So here, my intent is actually less, isn't it, than the harm that I've caused, if it's grievous bodily harm that I've caused. Okay, so we've got intent to injure, and the other mens rea, another option, the reckless disregard for the safety of others, right? I saw a risk, consciously took it, ran with the risk regardless. So again, 188 has these 3 different offences, with the intent to cause GBH, wound, or maims, or disfigures, or causes GBH. And then in subsection 2, with intent to injure, meaning actual bodily harm, somebody wounds or maims or disfigures or causes GBH. And finally, with the reckless disregard for the safety of another, wounds or maims or disfigures or causes GBH. Right? There are other interpersonal violence offences that are in the Crimes Act. The ones that we're going through are the ones that we want you to know. Okay? And 188, 189, these are really important kind of standard offences that are either built on the degree or the type of bodily harm. Aggravated wounding in section 191 is still an offence that is built not on an assault, but on a type or a degree of harm. So we bring it into this category. This is a really serious offence, 191. Anyone is liable up to 14 years, so it's really serious. Again, we've got our conduct, our actus reus down the bottom, that someone wounds or maims or disfigures or causes grievous bodily harm, or stupefies or renders unconscious, or by any violent means renders any person incapable of resistance. So lots of different forms of conduct, right? Lots of different potential actus reus. There's a new one here that we haven't looked at yet, to stupefy, which we're going to look at in a minute what that means. So that's our conduct down the bottom. The mens rea is the intent, so only intention, but it's intent to do one of those things in A, B, or C. So again, it follows through that if somebody with intent to commit, say an imprisonable offence, or with someone with intent to avoid detection of him or somebody else in the commission of an imprisonable offence, or if someone with intent to avoid being arrested or facilitate somebody else not being arrested from an imprisonable offence, if in the course of having that intention to do one of those things in A, B or C, they end up wounding, maiming, disfiguring, causing grievous bodily harm or stupefying, etc. The one thing to watch out for with a section 191 is it's very clear that when you're looking at the mens rea in terms of paragraph A, B or C, it's just intention that will suffice, right? So the prosecution have to prove that someone had the intent to do one of the things in A, B or C. What the courts have come to decide upon is that in relation to the conduct elements, right, the actus reus elements, which is the wounding, the maiming, the disfiguring, the causing GBH, the stupefying, the prosecution can prove either intention or recklessness. So the courts have brought in a kind of lower level of mens rea in relation to the actus reus component. So 191, that's probably the key thing to grasp. Prosecution has to be able to prove the intent when you're talking about the intent to do either paragraph A, B or C. So you intended to commit the commission of an imprisonable offence, or you intended to avoid arrest. But when it comes to the conduct that you actually did, which is the wounding, the maiming, the disfiguring, the causing grievous bodily harm, the stupefying, any one of those actual conducts that you ended up doing, the courts have said the prosecution can prove either that someone intended to wound or intended to maim, or, and it's so important because it lowers the standard, it lowers the level, doesn't it? Or they have to prove that someone was reckless. So in the wounding, they were recklessly, okay, they saw a risk and they carried on regardless. So we read in to section 191 the mens rea of recklessness that's not evident from the words in a strict reading of 191. We've read in this recklessness to go with an intention as an alternative to intention when it comes to the wounding, maiming, disfiguring, causing GBH, stupefying, rendering unconscious, rendering any person capable of resistance, all of those conducts. Okay. I'm just going to finish off this section by looking at a group of offences that are based on what I've termed dangerous activities, right? What's perceived as being a dangerous activity. Section 197 encapsulates an offence of what is talking about to disable, right? So you're causing the disabling is what it's talking about. And it talks about here that everyone is liable to imprisonment for a term not exceeding 5 years who willfully and without lawful justification or excuse, just means without a defence, stupefies or renders unconscious any other person. Where's our mens rea in that? What would we recognise as being a mens rea component? Willfully, brilliant. Does anyone know how do we interpret willfully? Intentionally. Perfect, right? Great. So here the prosecution is looking at intention, right? Has somebody intentionally stupefied or rendered unconscious? Now, to render unconscious, we know what that means. But what does this idea of stupefy mean? There was a case called Sturm, where it talked about that to stupefy means that you cause an effect on the mind or the nervous system of another person, which interferes with that person's mental or physical ability, basically to resist what is happening. Now, in the case of Sturm, it's a difficult case in terms of its fact pattern, in terms of what it was dealing with. A man gave a number of other men, who are the complainants, he gave a number of men ecstasy and speed in order to kind of reduce their inhibitions. So they weren't rendered unconscious, but they were rendered into it affected their mental processing and their state of mind, so much so that they couldn't then resist the kind of sexual advances that he was doing to them, the sexual behaviour that he was carrying out on them. Now, in the case of Sturm, they had to really unpack what does it mean to stupefy, because the defence tried to run an argument that actually to stupefy means to render unconscious. And these men hadn't been made unconscious. So the impact of the drugs had just meant that they were inhibited and not processing in a way that they would normally without the ecstasy and the speed, but it hadn't knocked them out completely. The court were very clear that to stupefy must have a different meaning from rendering unconscious. And that's because Section 197 makes it really clear that you can be liable if you willfully, intentionally stupefy or you render unconscious. So the court said in the case of Sturm, it must mean some altered state of mind that hasn't yet reached full unconsciousness, right? Otherwise, Parliament wouldn't have put in stupefy or render unconscious if they were to be seen as the same thing. So stupefy just means to cause an effect on someone's mind or nervous system, which means that their physical or mental ability to kind of resist what is happening. Okay. This relatively new offence that we brought in 2018 as part of a raft of family violence. So I'm sure, did Professor Tolmie, did Julia talk to you, I'm sure, about the Family Violence Death Review Committee that she chaired? She would have done it when you did the first semester around admissions. So she chaired it, and one of the amazing things that she and her other members of that Violence Death Review Committee was able to effect some law change, and this is one of them. This is Section 189, capital A. And this now makes it an offence, not exceeding for 7 years, if someone intentionally or recklessly impedes another's normal breathing or blood circulation or both, by either manually or using an aid, blocking that other person's nose, mouth or both, or applying pressure onto the other person's throat or neck or both. So it's now criminalising strangulation or suffocation, where someone intentionally or recklessly is impeding the other person's breathing. It's a view that in terms of the blocking the other person's nose or mouth or the applying pressure, that would need to be done intentionally. So it's not just being risky, it's intentionally applying the blocking of the nose or the mouth or applying pressure to the person of another, to that throat or neck. The intention and recklessness is about the impeding the other person's normal breathing or blood circulation. It's a really important offence that we now have on the books because, as the Family Violence Death Review said, strangulation is often a precursor to more fatal domestic violence and interpersonal violence offences or outcomes. So strangulation can be done as a way of exerting and showing control over another person, but in a way that sometimes may not even leave marks on the person. So it can be very hidden And so when they were reviewing all these fatal cases in the family violence death review, they found that a number of them had strangulation as kind of early precursor activity to show dominance, control, violence in a way that was kind of hidden. And so they advocated, and we now have Section 189A. And finally, there is a specific offence that's talked about where you infect with disease, so Section 201, infecting with disease. It says here that everyone is liable for imprisonment for a term not exceeding 14 years who willfully and without lawful justification or excuse, which again is just without a defence, causes or produces in any other person any disease or sickness. The key bit here is the mens rea of willfully. This has to be done intentionally. It's very rarely used. It's come up with some debate in the context of, say, transmission of HIV or transmission, say, of a sexually transmitted disease. But there's very few cases where anyone has ever been successfully convicted under a 201 because of that need for it to be willful. You would need to be able to show beyond reasonable doubt that someone intentionally wanted to infect that other person, say with the HIV or the STD. More normally, when we're talking about that level of, say, HIV transmission, we normally go down and we look at it as a Section 188, so that causing grievous bodily harm. We talk about the transmission of, say, the HIV virus. We talk about that as being the causing grievous bodily harm. And the reason we do that is that you'll remember from Section 188, subsection 2, it allows for a mens rea, doesn't it, where you have reckless disregard for the safety of others. So when you're causing grievous bodily harm, you have reckless disregard. So you don't have to intend it. It's just that you were reckless. So, for example, if somebody has unprotected sex with somebody else and they don't disclose that they've got the HIV virus, for example, the way we have traditionally dealt with it is that where there hasn't been any kind of informing of the other person, is we've dealt with this as being, if there's been a transmission, they talk about that as being grievous bodily harm, and it's reckless, right? Someone was aware of a risk, and they ran with that risk regardless. Now, remember whether something is actual bodily harm or whether it's grievous bodily harm is a matter of degree. Recent cases around this area, so that traditional case of Moai, which is the one that goes down a 188 subsection 2 route for when you infect a partner with HIV. A more recent case of Whilitonga in 2017 cast doubt on whether or not a jury would have to see that causing the transmission of HIV as being grievous bodily harm anymore. So back in the day of Moai in the mid-90s, the HIV transmission would have been seen more as a very serious illness, very serious chance of causing death, right? But given medical advances that we've had in this area, people now go on to lead with medication healthy lives, right, and long lives. And so it may not be the grievous bodily harm that it used to be. So Whilitonga just left open the possibility that it might be up for a jury to say this actually isn't grievous bodily harm, this is actually more actual bodily harm. But in any event, whether it's Moai at grievous bodily harm or Whilitonga at the actual bodily harm, the key is that we look at it in terms of looking at it as a form of bodily harm. When you've got the transmission of the HIV virus, we see that as bodily harm. We will come back to this next week when we start looking at sexual offences, because there's some argument that has been made that if someone doesn't disclose to you, say, their HIV status, that actually it doesn't just negate the risk of the bodily harm, but it might take away my consent completely to the sexual intercourse itself, which would raise it into a much more serious offence of sexual violation. So given that we're going to talk about sexual offences next week, let's come back to this. The final point on that slide is that there have been a number of cases where somebody has had unprotected sex, not disclosed the HIV status, but the person that they've slept with hasn't actually got the HIV, hasn't actually been transmitted. What we do, where we look at, okay, the HIV hasn't been transferred, but actually we've exposed someone to the risk of getting it, then we've looked at it through section 145, which you'll remember, hopefully, from the first semester, is our criminal nuisance provision. And here we say that the semen, the seminal fluids, becomes the dangerous object. And the failure to take proper care or exercise reasonable care, in this case, to say wear a condom, would mean that you have breached that legal duty. Now, because we put that breach of the legal duty of 156 into 145, which is criminal nuisance, it has a mens rea element, section 145, that you knowingly have to know that your omission would endanger the life or safety or health of another. Now, we'll come back to all of this when we look at sexual offences. I've left it for today because I want to be able to deal with the more detail around sexual offences when people know that that's coming up in the lecture. Okay, I want to put a boundary around it so that people are aware that that's what we're going to be talking about in our lecture for next week and the week after. So we'll come back to this point. The key point to remember is that when we're talking about HIV transmission or even transmission of, say, of sexually transmitted diseases, in New Zealand we've looked at this as being a form of bodily harm, whether that's grievous bodily harm or actual bodily harm. Brilliant. Right? We don't need to worry about that at the moment. So, that is the end of what I want to say about that last group of interpersonal violence offences that are built either on the degree or the type of bodily harm. So now we've been through the whole remit, right from our 196 common assault through to all those aggravated form of assaults, now to these more serious offences we've just looked at today that are built on the degree or type of bodily harm, whether it's actual bodily harm, grievous bodily harm, wounding, maiming, disfiguring, disabling. What we're going to do next is start looking at the specific defences that we can raise in relation to all of that group of interpersonal violence offences that are not fatal and non-sexual. It's 2:45. I think what I'll do is give you your 10-minute break now, if that's okay, so that you park what we've just done. And then when we come back in 10 minutes, which will be 2:55, so please be prompt back at 2:55, and we will start going through those specific defences. Okay, so see you in 10 minutes. prosecution were able to prove that he had the intention to murder under 127. It just meant that they had to prove he'd done an unlawful act, a dangerous act, which of course he did. So then you've got the probable homicide. The strangulation. Yeah. But they're not charging him with a 189A. They're charging him with probable homicide, which it was. So they're charging him with murder. Yeah. The interesting bit of that case is if the prosecution had not been successful with getting him to murder, there was an argument around the worry with the strangulation that because he was running an argument that we were just doing rough sex, it was all just risky and rough, but she consented to being strangled. It's just that accidentally went too far. So the judge said that he would have had to have left, if the prosecution, he would have had to have left it to the jury to consider if the prosecution hadn't been able to prove murder. He would have had to leave it to the prosecution to think about whether it would have been enough to say he didn't actually intend to strangle, he was intended to have a nice time. Yes. So that went to the intention that there was a strangulation that was objectively dangerous that caused the death. And that the fact that he had the pressure on him for so long disputed, I guess, it was able for the prosecution to say he clearly intended to do it, or he intended to do a really serious bodily injury that he was resistant to the history. Yes, it's interesting that had that failed. Exactly like that, yeah? Brilliant. I'm happy to talk after. Okay, welcome back. We're going to start straight into it. So, remembering all those different forms of interpersonal violence offences that are non-fatal, non-sexual that we've been talking about today and last week, we're now going to look at some specific defences that can be raised in relation to all of those offences that we've covered so far. Now, this area of law developed actually in relation to just an assault, but actually we now know that these specific defences arise much more broadly, so they can be for any of the type of offences that we've been looking at in the course in this particular module on interpersonal violence offences, non-fatal, non-sexual. Right, so you can run an argument against a 188 or a 191 or any of them, right? It's not just the lower level of assault. The one that we're going to spend the majority of time on is the defence of victim consent. There is that doctrine of common intercourse that we talked a little bit about last time, which is just that arguably the idea of implied consent, right? So social greetings, somebody shakes my hand, someone bumps past me on a crowded bus, someone taps my shoulder to get my attention. All of these things are just the stuff we do in the normal, everyday course of our life. They all are technically an assault because you've applied force to the person of another directly with the intention to apply that force. But we read into it, don't we, this idea of an implied consent. And then finally, domestic discipline. Now, given time, we may not get to domestic discipline today. If not, I've written it into our problem question on Friday and Thursday in our workshops, so we'll cover it there in detail if we don't get round to it today. I'd like to focus a lot of our time on this defence of victim consent. In addition to this very specific defences that we're going to look at today, obviously all the other general defences that you're going to learn about with me and with Lucy later in the course, like self-defence, are also potentially available, right? But these are just the specific ones we're going to look at. So let's get on with victim consent. Without going into the detail, because I'm going to leave that for when we come to sexual violation next week, at the heart of the offence of sexual violation, as part of the offence, so the actus reus and the mens rea, of sexual violation, a sexual offence, which we're going to learn about next week, is consent. Did someone consent? What was the other person's belief in their consent? For these interpersonal violence crimes that are not sexual offences, so the ones that we've been looking at last week and today, victim consent operates as a defence. So the prosecution still have to be able to prove the actus reus mens rea, right? The elements of the offence. Consent here, victim consent here, works as a defence, and it's preserved through that section 20, subsection 1 of the Crimes Act, which preserves the common law, right? So it brings into the common law defence of victim consent is preserved through section 20. Now, how this actually works then, this defence of victim consent, is that where there is evidence, where the defence thinks there is evidence that the other person actually consented, they will raise that evidence, right, which is called the evidential burden, right? The defence just has the burden of raising the evidence. The prosecution still have the persuasive burden. So it operates like normal, which is our normal kind of standard in most cases. The prosecution, the Crown, have the burden of proving beyond reasonable doubt. So once the defence puts it in as an issue, it's then still up to the Crown to be able to disprove that victim consent on the normal beyond reasonable doubt. So the persuasive burden stays as normal with the prosecution. Now, if it is successful, so in that sense, if the prosecution can't disprove it, then that will result in a complete acquittal. So it's a complete defence. Now, defences, like we're going to learn about later in the defences don't normally require any kind of mens rea element. But interestingly, New Zealand has adopted quite a unique approach to looking at this defence of victim consent. And those cases of Lee and Barker that you've read talk about that actually the defence of victim consent has a mens rea element. What they mean by this is that the defence, in terms of the evidential burden, they have to be, is there evidence that someone in fact consented? And is there evidence, if I'm the defence, that my client honestly believed that that other person consented? So subjective, honest, genuine belief, even if my client was mistaken as to that consent. So in that case of Lee, which was the exorcism case, Justice Glazebrook made it really clear that it is not enough just to look at whether in fact someone consented. What we have is this additional mens rea in inverted speech marks. We have this mens rea element that the defence would need to also be able to raise evidence that someone honestly believed they had the consent of the other person. So this means, of course, that the prosecution, remember the Crown, they have the burden still to prove it beyond reasonable doubt. They have to be able to prove that the victim in fact did not consent, but also that the defendant either knew that that victim did not consent or that the accused did not have an honest, genuine belief in the victim's consent. So this will take a while to see, for some it could take a bit of a while to sink in as you're getting familiar with it, because it's kind of a bit odd that we read in a mens rea into a defence. The question that we're going through in workshops on Thursday and Friday is dealing with exactly this kind of issue. So we will get a chance to go over it. The first thing to think about is there as a defence Is there any evidence the defence thinks can be raised to show that actually the victim, the complainant, consented? And then importantly, the defence will also put in evidence that actually the defendant had a genuine, honest belief, even if it was mistaken, in that person's consent. Once there is evidence of a defence of victim consent on the facts, then the judge will make a decision, sometimes, depending on the level of harm, whether to leave it to the jury to consider or whether to withdraw it. In most cases in New Zealand, because we take a very permissive approach, it will be left for the jury to consider. What this means then is that the Crown, the prosecution, have to prove both that the victim did not actually consent and that the accused or defendant knew that the other person wasn't consenting, or at least did not have an honest, genuine belief in that person's consent. So it's the talk of honest, genuine belief in the other person's consent raises this kind of mens rea element. One of the issues, and again we'll look at it in much more detail next week because it arises also in sexual offences, is what happens if someone gives their consent but it is based on a mistake. So I give my consent to someone to do something to me, say bodily injury, but actually I was mistaken about something. Traditionally, this has been viewed very, very narrowly. So normally, the only time that you would say vitiate someone's consent, if you were mistaken as to the nature of the act itself or the identity of the person doing the act. So say you understood the nature of the act to be different from what actually was happening, or the identity of the person was different from who you thought was doing it. As I mentioned, I'm going to go through those exceptions around nature and nature of the act and identity of the person much more next week because it comes up again when we look at sexual offences. We'll come back to this idea about where you've got consent but it's based on a mistake. One of the areas that's kind of prevalent and one of the areas where it comes up probably the most in our context, again, is in this transfer of HIV. And we will talk about this again more when we do sexual offences because it's been raised about if somebody, Justice Glazebrook and Obiter in the case of Lee, made it really clear that there was kind of a duty on the defendant to disclose the HIV status. So she talked about that there was this duty to inform, right? If you're going to have unprotected sex with somebody and you know you have, say, HIV, there is a duty, an informed consent, right? You've got to give somebody an informed consent so they know what they're agreeing to. Because they talk about, obviously, there is a difference between having sexual intercourse with somebody who doesn't have HIV and someone who does have HIV in terms of the risk that you're taking on. So Glazebrook and Obiter said that an informed consent was necessary to discharge that kind of duty, right, to inform somebody about it. Unless you wore a condom. So if somebody wears a condom, Glazebrook said that there would be enough to discharge the duty to inform, right? Because you've taken steps to mitigate the transmission of that HIV. We'll go back over this, as I said, in more detail when we come to sexual offences. So, victim consent can be expressed, so by someone's words or by conduct or both. Consent can be implied. So consent could be implied through someone's action. So this commonly comes up, for example, in contact sports. So every time someone steps onto, say, a rugby field or into a boxing ring, they have given an implied consent to what happens to them when they're on the field or on the boxing ring, right? So the argument runs, if you voluntarily participate in, say, contact sports, then you impliedly are giving your consent to the physical application of force. Problem happens, of course, is what happens when someone goes beyond the parameters of what you've kind of impliedly agreed to. Now, in New Zealand and Australia, we don't tend to prosecute for infringements where someone has gone beyond what would be a normal physical application of force. And there's been some fairly gruesome cases where people have done things to each other, say on a rugby field or a rugby league game, that in any other context would be a criminal offence. We tend to, in New Zealand and Australia, leave it up to the sporting bodies to regulate it, perhaps because of the culture we have around sport, perhaps because we don't want to clog our courts up. We think that the specialist knowledge of the regulatory body are better to be able to make these decisions. So what we're going to do quickly is just look at a couple of cases from other jurisdictions that have tried to deal with this issue about what happens when somebody has been injured, say in a sports context, and in a sports context, when is it that I've just am given my consent because I've signed up to play the game, and when has somebody gone beyond the parameters of what you'd accept to happen to you? Now, in Canada, this has come up a lot in the case of ice hockey. So anyone who's watched ice hockey probably isn't surprised, given the kind of contact and sometimes unpredictable nature of the sport. The case of Say is actually quite an old case now. Way back in 1989, the top court, one of the top courts, had to look at this particular point. And the court, in the case of Say, so it's a Canadian case, said that ordinarily consent is something that you would see as being a subjective matter. But they say when you're looking at implied consent, and when you're looking at it in the case of like a team sport, there cannot be lots of different consents, because obviously every time a player steps onto the ice for the ice hockey or onto the field for a rugby or a league game, every player will have a different level, won't they, in their own mind about what they're agreeing to, the parameters of when the physical application of force will go beyond what they expect to happen to them. And so the judge is saying here that you can't bring in all those subjective understandings, so you have to have a more uniform approach. You have to determine it by reference to a more objective criteria. So in this case of Say, they talked about that you needed to look at the conditions under which the game is played. So is it a professional game? Is it an amateur game? What was the actual explicit specific act that was under investigation? What was the extent of the force that was used? What was the degree of the risk of injury? What were the probabilities of serious harm? In England, they pretty much follow that case of Say. So one of the big leading cases is the case of Barnes. It was a football scenario where the English Court of Appeal followed the Canadian approach and Say, and basically said that when you do these highly competitive sports, every time you step onto the field, you are giving an implied consent to the application of physical force upon you. And even when, in the heat of the moment, someone does something that in the nature of the sport might contravene the sport regulation, so you could be sent off, for example, or given a red card or sin-binned, that doesn't necessarily mean that what you've done is going to be enough to be criminal. Right? So the question is kind of at what level are you going beyond an accepted level of physical violence? And it doesn't mean when people do things that might give them a penalty in terms of the sport itself, like a red card or a time off. And the court, in that case of Barnes, the Court of Appeal said that you have to go beyond kind of what players could reasonably, the objective, reasonably regarded as having accepted by when they take part in the sport. And this is where they use that objective approach from the Canadian case of Say, by saying the type of sport, the level at which it's played, so is it amateur, is it professional, the degree of force, the risk, the injury, these are all things that get taken into account. And they said to the jury, you have to ask yourself, was the conduct, like such an obviously late tackle, so violent that it couldn't just be instinctive or a misjudgment in the heat of the game? The main points to take away from these couple of cases is that, one, there is this notion of consent can be implied, and one of our clearest examples is through sport, through contact sports. You imply a consent to the application of physical force each time you go in the boxing ring, on the sports field, if it's a contact sport. The question then goes, at what point has someone gone beyond it? Now, the case of Barnes and Say, in one sense, people say, is at least an acknowledgement that sometimes things can happen in a boxing ring or on a sports field that actually should be criminalised. That just leaving it to the regulatory board is not enough. But it is still really hard, even in those jurisdictions where that's more set up for that kind of approach, it's still really hard to be able to say that somebody has gone beyond a certain level of accepted level of violence, right? It still allows for people to do high tackles and stuff that you would be sin-bin for and stuff that your regulatory board might give you a penalty for or fine you for. It still doesn't mean it's a criminal matter. Interestingly, in our jurisdiction, we just have very rarely does this kind of thing come to court. We leave it to the regulatory board. So for anyone interested in doing work in that area, it's quite an interesting topic to research how much we want to follow other countries. Okay. What I'd like to do now is just raise with you some of these big policy issues that I think, public policy questions that I think are behind this idea of victim consent. And then we will look to the case of Lee and Barker and the case of S in the Queen to see what they say on the matter of this defence of victim consent. The slides have got lots of different issues on them, and I'm not going to go through all of them in the lecture today, but at some time when you're revising your notes and have a look at some more of the detail on the slide, because what you'll see is that victim consent raises multiple complex, nuanced issues. You have to think about, was the victim actually capable of consenting? You have to think about, was the victim mistaken in the consent that they gave, and therefore would that consent vitiate or take away the consent? What are the parameters of the victim's consent? That's the issue with the contact sport, right? How much of violence am I agreeing to when I take part in this contact sport? These public policy issues situate around the social utility of the activity, concerns about preventing harm, concerns about victim vulnerability. In other jurisdictions like England, there's a big emphasis on morality, not so much in New Zealand. New Zealand tends to put a much higher regard for a personal autonomy. We have, if you could say that England takes a really restrictive approach, New Zealand would take a really permissive approach in terms of allowing people to agree to the infliction of harm upon themselves. So the social utility of the activity are things like if it's seen to have a benefit to society. So sports, for example, like boxing or rugby, these contact sports. Surgery is one of the things we talked about last week where you agree to violence upon you. We'll see in the case of Lee, which is the case dealing with exorcism, that the court held that the exorcism was a manifestation of a religious belief, and that's protected under the Bill of Rights Act. Public policy around prevention of harm, both to the individual but actually to the collective, to the society. So what level of harm is being risked or intended against a victim? Are there safety mechanisms around that harm to minimise it happening? What's the cost to the public to maintaining the victim if we allow violence in a certain conduct? Does that mean that we're allowing people to hurt each other? And does that sort of somehow take away from the kind of society that we want to be? What we do see in the cases coming in New Zealand, as you can see in the case of the dissenting decision in Barker and in the case of S, big concerns about victim vulnerability. Vulnerability because of the victim's age, so if you get big age differentials between the defendant and the victim, but vulnerability in terms of mental capacity, untreated psychological trauma, if someone has been drinking or under the influence of drugs, so it doubts about someone's personal autonomy. Kind of those exploitative circumstances where there's an imbalance of power. As I mentioned, in New Zealand, there's less concern on morality. We'll come to look at the case of Brown, which I think you did in part 1, in a minute, but you'll see in the English case of Brown a really strong leaning towards this morality, the sanctity of the human body, not violence can be evil, these kind of language, cruelty. So we're left with a balancing act, right? We're left with how much do we put value on protecting people, or do we put the value on personal autonomy? At what level of harm are we willing to say that there will be some kind of benefit to society by allowing that to happen? So as we talked about last week, there are lots of cases, aren't there, where we allow harm or violence to be inflicted on our bodies, whether that's piercings, whether that's surgery, whether that's tattoos, scarification in a cultural context. So how much do we want the court to be involved in saying, well, actually people can't consent to a level of harm? Now, as I mentioned to you, England in particular, and the reason I'm raising the English approach is just because it takes such a different approach from what we do in New Zealand. And it's very much determined by a public policy that is very restrictive, very about shutting down personal autonomy, and very much saying that you cannot consent to a level of harm of actual bodily harm or above. Now, remember, actual bodily harm is just kind of trivial, right? So it's between more than trivial and not really serious. So they set that at a really low standard. Australia sets it at grievous bodily harm, right? You can't consent to harm if you're inflicting grievous bodily harm on yourselves. Okay. Hopefully you might remember. Do you remember the case of Brown? Did you do this in part 1 with Mark? Yeah, Professor Hennigan, yeah. So this is a case involved I think it was about 10 men who were homosexual, who were then inflicting a whole range of physical application of force onto parts of their body. I can hear from the murmuring that you might remember it. So one part of it is that they like to video what they did, and that video got into the hands of the police. And so the police then decide, right, we're going to have a look at what's going on here. What you will hopefully remember from that case is that the House of Lords took a really restricted view, some would argue quite a moralistic view. One of the Lords talked about that cruelty is uncivilised. They talked about things as being evil. They talked about that this activity that these homosexual men were doing on each other was somehow breaking up the fabric of society. They talked about it being a relief that one of the younger men had now been in a settled heterosexual relationship. Right? So really strong, some would argue, moralistic tones coming through the judgment. Why this case is really important for us is because it's a really clear difference to the approach we take in New Zealand. So what they did in the case of Brown and the House of Lords, they basically said that you cannot consent to actual bodily harm and above unless it falls into a category, an exception. So they did a sort of standard approach of saying people cannot consent to actual bodily harm that's intended or caused, unless it falls within an exception. So surgery is an exception. Tattoos and piercings can be an exception. Contact sports is an exception. They came up with these exceptions. That idea of categorising into this kind of an exceptions, these categories, is very different from what we do, right, in New Zealand. I'm just going to very quickly give you a couple of cases that were followed Brown that in a way kind of show the difficulty with implementing that Brown really restrictive approach, remembering this is in the English. The reason I put Wilson there is it's similar actually to a fact pattern that we look at on Friday where someone brands their initials onto the part of a body of their partner. And in Wilson, in the Court of Appeal, they were quite happy to say that this was just akin to body piercing. Now, interestingly, this involved a heterosexual couple. So given that it was so close to the decision in Brown, people have criticised it, saying, did it make a difference? And interestingly, in that Wilson case, the court talks about what goes behind closed doors within the sanctity of marriage is not for us to look at. So you can see these real double standards coming through. Emmett proved really problematic because it involved very serious harm to someone's body. And they said no, they followed Brown here and said absolutely not. People cannot consent to actual bodily harm and above in the context even of consensual sadomasochistic sex. Okay? Let's have a look through then about what we do in New Zealand. The first case that we're going to look at is the case of Lee. This was the case involving the exorcism where sadly the victim died. And Lee was up on a charge of manslaughter. We know we have to find an unlawful act that's dangerous and that causes the death. But if there's no unlawful act, then there can be no culpable homicide. So this exorcism on religious grounds meant that the defendant placed pressure onto the woman's torso, for example, and impinged her breathing so much so that she died as a result. At the trial, the judge said that the evidence around that the victim consented to the exorcism, therefore consenting to this behaviour, shouldn't be looked at by the jury, right? He withheld that defence of victim consent. Therefore, Lee originally was convicted of manslaughter, so it went on appeal, and it went on appeal on this point of law, right? That was the trial judge right to withhold the defence of consent. Remembering that in criminal law, your point of appeal is going on the point of law, right? So the Court of Appeal have to look at, was the trial judge right to withhold the defence of victim consent? And they, by the majority, say no, that the trial judge was not right to withhold the defence of victim consent from being considered by the jury. And this quote on the screen really kind of encapsulates why. And they say in the bit I've underlined that a high value has to be placed on personal autonomy. So respecting choice, right? So what they did in the majority in Lee is come up with these four kind of distinct tiers. And they say, like at the lower end, in the first category, that if no bodily harm is intended or risked by the defendant, then consent is a complete defence, right? In the second tier, they say that if it's actual bodily harm that's being intended or risked, then consent should normally be a defence, except for in non-sporting fighting, right? So street fighting. But other than that, consent should be a defence. Then in the third tier, they say that where grievous, so really serious harm, is intended or risked, then consent again should generally be a defence. But they say the judge can have a look at it and balance up some of those public policy issues. So when you're talking about a level of grievous bodily harm being intended or risked, then the judge can, when it's deciding whether it wants this defence to go to the jury, can go, okay, let's balance what was the harm to the individual or society, what about victim vulnerability, what about personal autonomy. It can weigh up all these public policy questions. Is there any kind of social utility in the activity? And if it finds that on the grounds of that public policy it wants to withdraw it from the jury to consider, it can do. And then finally, in the last tier, if death is intended or risked, then consent will never be a defence. One of the first things I want you to pick up about these different tiers from Lee is that they are talking not about the actual harm that's caused. They're talking about the level of bodily harm that is intended or risked. Right? That's probably one of the most important things to take away from today, is that they're not talking about the actual harm caused, they're talking about the level of bodily harm that's been intended or risked by the accused. And our two big kind of tiers are 2 and 3. Because 2 is saying that where actual bodily harm is intended or risked by the defendant, then consent will normally, generally as a defence, except for in the case of, say, street fighting. With grievous bodily harm under tier 3, where grievous bodily harm is intended or risked, again, consent can be a defence. But at this stage, because you're talking about grievous bodily harm, the judge can get in on it and can start weighing up those public policy arguments and see whether there are any reasons on public policy that they decide they don't want to leave it to the jury to consider. But of course, that's not the end of the matter, right? Here we're just looking at, as the defence, we go, we've got some evidence we'd like to put into play that actually the victim consented and actually my client had an honest, genuine belief in their consent. What those tiers in Lee are saying is that if it's actual bodily harm that's risked or intended, that should be put then to the jury to consider. If it's intended or risked grievous bodily harm by the defendant, then the judge, if they want to, before giving it to the jury to consider, can decide, are there public policy reasons like victim vulnerability, lack of social utility, that we want to stop the jury from looking at this defence? Does that make sense, those two different approaches? So it's not the end of the matter, because if the defence gets left to the jury to consider, obviously a jury, on the facts of it, can make their own mind up as to whether someone in fact consented or whether the defendant had an honest belief in it, in that consent. What we're looking at now is the next case, which is the next big case in New Zealand. So 3 big cases in New Zealand that I want you by the end of this week to be really familiar with. So we'll have a chance to practice them in the workshops. The second one is the case of Barker. Now, like a lot of criminal law, it's dealing with really difficult fact patterns. So as I've said to you a number of times now, we really understand that criminal law can be quite a difficult subject to read about. And if it is, then please reach out. So come and see me or Lucy or Julia, or reach out for support if you want help with navigating some of the content. In Barker, it involved a man, I think he was in his 30s, the defendant, well into his 30s, the defendant. he'd set up kind of like a bondage, sadomasochistic kind of den, right, room. And he, through using drugs and alcohol, he'd managed to get a young 15-year-old girl and a 17-year-old girl to come into this room and take part in different activities that were kind of sadomasochistic sexual activity, risky, dangerous activities. The 15-year-old complainant had a history of self-harming, and the accused ended up cutting into her shoulder an image, a sort of emblem of a dragon, his emblem. The 17-year-old, who had already taken drugs, he cut her all over her breasts and her torso in really messy cuts across the front of her body. Probably what was one of the most interesting and has been often quite contested and criticised is that the trial judge in the Barker case found that the injuries that had been intended or risks by the defendant were at the level of actual bodily harm. What does that mean if we think about those tears of Lee? What does that mean? If the injury that is being risked or intended is at actual bodily harm, what's our normal approach in terms of the defence of consent? Yeah? It's available, right? Lee makes it clear, doesn't it, if we go back to our tears, that the number 2, actual bodily harm intended or risked by the accused, consent is generally a defence unless it's this street fighting, which this isn't. Right? So should straight go to the jury to consider. However, at the trial in Barker, the judge felt that the level of injury to these 2 young girls was such that he would withhold the defence of consent. So the jury were not able to look at the defence of consent at trial. So Barker and his counsel, they put in an appeal that following Lee, it was an incorrect application of Lee, that the defence of victim consent should have been left to the jury on a point of law to look at. The Court of Appeal in Barker, in the majority, agreed. Now, many of the people that were on the bench in Barker were the same judges that were on Lee and had been the one that had brought in those tears. So they agreed that the defence of victim consent should have been left to the jury. So the trial judge was wrong to withhold it from the jury. And in the majority, the judges came up with a number of different reasons. Justice O'Regan said that actually the only exception that Lee sets down is to the defence of consent is street fighting, and this is not another exception. And they did not want to make, Justice O'Regan was really clear that scarification, so that was the cutting of her torso and her breasts, that scarification itself in a different context can have a cultural context to it. And that shouldn't be something that we put an exception about, right? So we don't want to create kind of exceptions. Interestingly, in New Zealand, we don't do it by categories or exceptions, right? It's more on an individual basis. It's very different than the approach they take in England, for example. The judge, Justice O'Regan, was very clear to say that Lee, in that tier system, only says that the judge can get into that balancing process about whether we're going to allow the defence to be looked at by the jury if you are intending or risking grievous bodily harm. And this had been set at that actual bodily harm. Justice Hammond talks about, we value, as the case of Lee said in the Court of Appeal, it's all about personal autonomy. Right? We don't want the law and therefore the courts to get muddled into people's personal autonomy, right? And so we want to reject, as he says, rejection of paternalism, right? He says, why would the court be better placed than an individual to know what is good for them? Wow. This opinion by Justice Glazebrook in dissent, so this is the dissenting opinion, is really important for us to understand. Despite that Justice Glazebrook had been on the majority in the case of Lee and had helped to do the 4 tiers, given this fact pattern, She had serious reservations about the application of those tears in this particular case on these facts. And I imagine felt really constrained by the Lee approach, right? Because the trial judge, and she was very critical that the trial judge had incorrectly put the level of harm risked or intended as being actual bodily harm. She thought this is two young girls, and the level of extent of the harm on their bodies was such that it should have been a much more serious, say, of grievous bodily harm risked or intended. But nevertheless, she was stuck with the risked or intended of actual bodily harm. She wanted to do several things. She wanted to create a new category I'll come back to this side, but she wanted to say that scarification, when it was in a sexual context, i.e. not a cultural one, that scarification of a sexual context of a child under 16 should be one of those exceptions where even if it's actual bodily harm that's risked or intended, we allow the judge to withhold the defence of consent. She really felt, particularly in the case of the 17-year-old who suffered all those cuts to the front of her body, she really felt that the harm that was intended or risked was much more towards the level of grievous bodily harm. As I said, she thought that the judge at the trial was incorrect to say that this was actual bodily harm risked or intended. She talked about the vulnerability of the complainant, the age disparity, a guy in his late 30s, younger girls, the drug taking, the alcohol use, the bondage, discipline, sadomasochistic environment, the messy, unprofessional nature of the scarification. All of that said it outweighed any kind of social utility and outweighed personal autonomy. So she really wanted to find a way that you could push aside that issue that if it was just risked or intended grievous, actual bodily harm, that it had to go straight to the jury to consider. So what she came up with, and this is really important, is that she came up with something called a sliding scale. And so she said, if over here you've got actual bodily harm, right, so over here, actual bodily harm, and over here at the more serious end you've got grievous, really serious harm. She said, there is a whole bunch of harm, isn't there, in between that. You could have harm that's just a little bit more than actual bodily harm, remembering that actual bodily harm is just more than trivial. And then you could have harm that's not grievous, not really serious, but is getting to the upper end, isn't it, of actual bodily harm. And of course, as she's saying, that makes a massive difference. But what we're doing in Lee is that those distinct tiers mean that every time it's actual bodily harm, risked or intended, it all just goes to the jury to consider the victim consent. So what she's saying with the sliding scale approach is that the more serious the harm that's intended or risked, the more likely it is that the judge should be able to get in and do those public policy factors and weighing up. So what she, and this is only at this stage in the dissent, what she wanted in dissent was to be able to go, the closer the harm that's risked or intended gets to grievous bodily harm, even if it's still been said to be actual bodily harm, if it's risked or intended actual bodily harm, but it's getting really close to a level of really serious harm, risked or intended, the more likely it is that the judge should be able to weigh up those public policy. So Lee is still good law, but what she's doing is trying to introduce a sliding scale rather than these distinct tiers. So she wants more flexibility. At this stage, as I said, we're only in dissent. The final case in New Zealand that I want to look at with you today is a case of S and the Queen. Again, involves an older man with a young girl. I think when they met, she was around about 16. She was a couple of years older. I can't remember. Maybe she was 17 when the behaviour went on. She had been in and out of care and foster care most of her growing up. She'd basically been hitchhiking and essentially been picked up by this guy in his 30s, and she came to live with him and his children. Again, it's a really disturbing fact pattern. He accuses her essentially of molesting or interfering with one of his children, which she denied. And this kind of harassment of her to get her to agree that she did do the behaviour with the child just relentlessly carries on, and she keeps denying it. Imagine she's a very young girl, she's got no other family, she's financially dependent on this guy. She gets to a point that she agrees, yes, I've done it, right? She wants to keep the relationship. She agrees that he can smash her finger with a hammer, so it's really disturbing. And so she consents to it on the facts, right? I agree. You can do this as my punishment. At the trial, the judge said that although they had again determined that this was a level of injury that was risked or intended of actual bodily harm, despite saying that the defendant had risked or intended actual bodily harm, the trial judge didn't follow Lee. So didn't follow the tiered approach in Lee, because if they had have followed Lee, then they would have said the jury automatically needs to consider this defence of victim consent. Because the defendant raised evidence that she had consented and they had an honest, genuine belief in her consent, right? There was evidence of that. So the trial judge said, I'm going to withdraw the defence of victim consent. And therefore he was convicted. He then appeals that actually this was an incorrect application of Lee. And it was on the point of law, right, in the sense that Lee has these 4 distinct tiers, and if you intend or risk actual bodily harm, then the jury should consider the defence of victim consent. So the argument was that the trial judge was wrong to withhold it. The Court of Appeal, who this time has Glazebrook again, Justice Glazebrook on the Court of Appeal, the Court of Appeal actually said that the trial judge was right not to put this in front of the jury. But of course they've got to come up with a way in which they're going to get some flexibility into that tiers of Lee, right? And they do it by bringing that sliding scale that Justice Glazebrook talks about in dissent in the case of the Queen and Barker. They bring it into their majority decision, right? They bring it into their decision in the case of S and the Queen. So what S and the Queen is a really important case for is it says that there is that sliding scale of harm between what is actual bodily harm and when you go up to grievous bodily harm. And although the trial judge put that the risk of harm that was intended or risked was at actual bodily harm, they said the broken finger gets towards the higher end of that. So not grievous bodily harm, but nearly up to risking or intending grievous bodily harm on that sliding scale. And in that way, they were able to disallow the appeal, right? They were able to say, although the trial judge didn't follow Lee, they brought in that sliding scale, right? So they were able to disallow the appeal. So now we have a situation where when we're thinking about the defence of victim consent, we've got the first question about whether the defence has got any evidence that they can raise that someone in fact consented, and can they show evidence that their defendant had a genuine, honest belief in that person's consent. If that is evidence that they can raise, then it comes to be considered, and following Lee, we still use these categories, and we would still go, in most cases, if it's actual bodily harm, risked or intended, then the jury should look at it. But what our sliding scale from the case of S and the Queen does is it allows us to say that even where it's risked or intended actual bodily harm, if it's getting closer to that higher end towards grievous bodily harm, then it might be the judge can get in and do that public policy. What's the social utility? What about victim vulnerability? So what the S and the Queen does is just allow that chance for the judge to come in and do the weighing up of those considerations, even if it's actual bodily harm that's been risked or intended. So what the trial judge and the Court of Appeal agreed with, what the trial judge had said is that there is just no social utility in the deliberate infliction of harm in the context of a domestic relationship. And they talked about that the reason why they wanted to withhold the defence of victim consent from the jury was that domestic violence, family violence, we know is a big problem, a major problem in New Zealand. There was a significant power imbalance between the much older man and the younger woman. The victim was incredibly vulnerable. She was vulnerable by her age, but she was also vulnerable. She had no family other than the man. She had no financial independence. She had herself a history of mental health difficulty. She had on record self-harm. She had past untreated trauma from her childhood. So all of those things meant that the trial judge felt that those were good reasons why we shouldn't leave the jury to think about victim consent. So the key thing from S and the Queen is that we now have Justice Glazebrook's sliding scale that she talked about in Dissent in Barker. We now have it as part of the decision, right? So when we look at victim consent, we need to know about those tiers in Lee, because it will often be the case that if someone intends or risks actual bodily harm, defence goes straight to the jury to consider. If someone intends or risks grievous bodily harm, then the judge can do that weighing up of those public policy considerations. What the Queen and S has done is brought that sliding scale into our approach now and go, if there is somehow, it's still risked or intended actual bodily harm, but it's getting to the higher end towards grievous bodily harm, being risked or intended, then the judge still can get involved in weighing up those public policy considerations. And you will see the courts wanting to do that in cases like the case of Barker and the case of S on the facts, where you're dealing with victim vulnerability, right, where there's a lot of age and power differential. One of the final point I want to make is that when you're thinking about S and the Queen, one of the things that they said in the judgment, which is really important, and they kind of give more of a finesse or tease out something that Glazebrook didn't in her dissenting opinion in Barker, is they make a distinction between harm that is risked or harm that is intended. Remembering that, of course, intended harm is more higher level of intention, isn't it? Because it's our highest form of mens rea. Risked is just being reckless, right? An aversion recklessness. I'm consciously taking a risk and carrying on regardless. So what they did in the case of S and the Queen is that they drew a distinction between where you intend the harm or where you risk the harm. And they say the more likely that you intend the greater harm, okay, so the more likely that you've intended a higher level of actual bodily harm that's getting close to grievous but not quite, the more likely it is that the defence of consent will be withdrawn. So that would make sense, right? So the more likely that you've intended harm that's actual bodily harm, but it's getting really close to intending grievous bodily harm, the more likely it is that the judge will withdraw the defence of consent to be looked at from the jury. Where that harm is risked rather than intended, it could be that a judge decides then to leave it to the jury to consider. On Thursday and Friday, you'll see the worksheet is up on the Canvas page for us to work through. It involves a situation where a guy brands a younger female. So it's pulling up, just 2 seconds please. It's pulling up, I've got 2 minutes left and I'm going to use them, sorry. It's pulling up the situation of this defence of victim consent. Well done if you've read Lee and Barker and the Queen and S. If you haven't, could you please read them for Thursday and Friday? We will do, if I could have your attention please, it's not quite 5-2. If we could have you ready to also look at domestic discipline, so it's a specific offence that's raised where there's an application of force on a child by a parent or someone in place of a parent. It comes up in the facts in our workshops. We'll have a look at it then as well. I just want to say that next week we start a 2-week block on sexual offences. So just to give people advance warning that that is coming up. If you would like support with navigating that material, then please come and see myself or Lucy or Julia if you're comfortable. And if you feel that you would benefit from some support around that area, or indeed any of these interpersonal violence offences, then the university has a really good counselling service with trained counsellors, and you can just go and get some support as well. So the main message is, I understand completely this is a really difficult part of criminal law, this block of offences on interpersonal violence offences and sex offences we're starting to move on to. I'm really grateful for the way that you're engaging in the lectures and workshops in such a sensitive and mature way, so thank you for that. It's a really considerate way for the people around you that may have experience of these kind of offences or know loved ones that do. So thank you for that, and I look forward to seeing you in workshops on Thursday and Friday. Have a good rest of your evening. I'll just pack up and then I'll see you just in case somebody else comes in. Out and then we'll get going.